Good morning, everybody. Thank you for joining me for today's webinar. My name is Amber Hines, and I'm the owner of Ashbur, where we specialize in Medicaid compliant annuities. Today, we're going to be talking about how to handle previous gifting in married couple crisis situations. If you're interested in a copy of the slides from today's program, you can find those in the handouts portion of the GoToWebinar dashboard. And also, if you have questions during today's presentation, feel free to type those in the questions bar of the GoToWebinar dashboard as well. I'll start out just telling you a little bit about myself. Again, I'm Amber Hines, and in January, I will have spent the last 20 years working with elder law and estate planning attorneys across the country to specialize in Medicaid compliant annuities. I am insurance licensed in all states and hold a Series 65 license with FINRA. And I created Ashbur to assist advisors as well as elder law attorneys with pre-planning and crisis Medicaid planning solutions. The pre-planning solutions are really geared more towards hybrid long-term care insurance policies, some traditional long-term care insurance policies if clients are healthy enough in order to qualify for those types of contracts. And then on the crisis planning side of things, we specialize not only in the annuity products, but also if you have clients that are in need of prepaid funeral policies that are going to be considered exempt for Medicaid qualification, we can help with those as well. We can help you and your clients by offering complimentary case analysis. So we can help you to determine the optimal amount to put into an annuity policy, the term of the annuity that could be considered, and then also which assets your clients may consider annuitizing. This is going to be especially important when we have situations where clients have IRAs or other non-qualified annuities that need to be transferred into a Medicaid compliant annuity. We can help with doing direct transfers of those types of accounts to avoid tax consequences so that the money flows directly from either an IRA or a non-qualified annuity or even whole life insurance policies through a 1035 exchange into a Medicaid compliant annuity contract. We offer assistance from the beginning to the end of a case. So we will help with providing quotes for your clients to consider. We help with the actual funding of the annuity contracts. Again, this is going to be especially important when we have clients with IRAs or non-qualified annuities that we're trying to transfer into a Medicaid annuity without tax consequence. And then also we help with the death claim process if that becomes necessary. So in most cases, when we set up a Medicaid annuity, the state Medicaid agency is going to be listed as a beneficiary. And so if we do have a client that passes away during the time frame of the annuity contract, we would reach out to the state Medicaid agency, obtain documentation as to whether the state has provided any Medicaid to that person, and then work with the contingent beneficiaries to get them paid out on the remaining policy the remaining policy value that would be available. We do work with A-rated insurance carriers, and we offer top-notch customer service as far as getting back to you in a timely fashion. In most cases, we're able to get back to you same day with a proposal of how to qualify the client for Medicaid, and then also help with the funding of the annuity contract as well. We do offer lower processing fees than our competitors as far as if there is a processing fee that would be due to our company for a short-term annuity, our fees are always lower than our competitors. So that's also something to consider as well. When we're talking about crisis Medicaid planning and the goals that we're trying to achieve when crisis planning, we're generally trying to convert countable assets or resources into non-countable assets. And we're trying to do this in the most cost-effective, tax-efficient way. So we're going to consider the types of accounts that your clients own and not just suggest that everything be liquidated and transferred into a Medicaid annuity. We're going to look at the life expectancy of that person and also the potential tax consequences of liquidating existing accounts in order to achieve Medicaid eligibility when we are coming up with our recommendation. Also, we're trying to obtain immediate Medicaid eligibility as quickly as possible without any kind of private pay or penalty period, which is what we're going to be talking mostly about today. If there are previous gifts or transfers, then how do we handle those in order to get the person onto Medicaid as quickly as possible? Also, we're going to try and minimize or avoid estate recovery if we can. And so if we're looking at the income and asset limitation for married couples, generally the income limitation for a married couple, if we're considering one spouse that is in a nursing home and applying for Medicaid and the other spouse is still at home, I'm going to refer to the spouse that is at home as the community spouse. The community spouse is able to have unlimited monthly income without any income limitation for the spouse that is residing at home. There are only 2 states currently, New York and Illinois, that will require in some cases for the community spouse to contribute some of their income to the Medicaid applicant's cost of care, but that's a rare situation. So generally in most situations, the community spouse is able to have unlimited monthly income by way of the annuity or other income sources without it affecting the Medicaid applicant's cost of care, their share of cost. The Medicaid applicant or the institutionalized person, their income must be less than the cost of care unless we're working in an income cap state. And if we're in an income cap state, then their income is capped at $2,829 currently. That's a 2024 number. And so if we are working with a Medicaid applicant that has income that exceeds the $2,829 per month, then a Miller Trust or a qualified income trust would have to be established in that state in order for the excess income to flow through the Miller Trust before paying the share of cost. And so the QIT or the Miller Trust is a way in income cap states to make sure that the Medicaid applicant is going to be income eligible when the Medicaid application is submitted. When we're talking about assets for a married couple, usually the institutionalized person or the Medicaid applicant is able to keep around $2,000 of assets in their name. This does vary slightly from state to state, but the most common number is $2,000 that the Medicaid applicant can keep. When we're talking about a community spouse or the spouse that is residing in the home and not applying for Medicaid, they generally are able to keep around 1/2 of the couple's countable resources up to a current maximum of $154,140. And again, that's a 2024 number. That number is going to increase in the beginning of 2025. I looked just before getting on this webinar, and those numbers haven't been published yet, but the $154,140 is going to be the cap amount that the well spouse is able to keep. Other resources that are considered protected or exempt when applying for Medicaid are usually the family home, especially if the well spouse is residing in that home. That is not something that is going to be considered countable for qualification purposes. Also, one automobile or vehicle that the couple owns is going to be exempt as well. Their household goods and personal property, as well as an irrevocable funeral trust or prepaid burial policy, is not going to be countable either. And then also in some states, IRAs are going to be an exempt asset, but that's less common for IRAs of the couple to be considered an exempt asset, but is something to consider if you are in a state that doesn't look at the IRA value or the retirement account as a countable asset. If we do have a situation where we have clients that have too many assets in order to qualify, we're generally going to put together a Medicaid eligibility plan, and that can include increasing or improving non-countable assets, making improvements to the family home, purchasing a new car if that's necessary, or any household items that the couple can consider using excess resources in order to purchase a non-countable asset. That is going to be one way to spend down excess resources that the couple has. Another item that they can consider is the prepaid burial policies that we talked about, because that's not going to be considered a countable asset. We can also pay off credit cards, mortgages, or other debt that the family has. And then finally, if there are resources that are remaining after all of these items are considered, we can consider purchasing a Medicaid compliant annuity that would comply with the Deficit Reduction Act of 2005. The language that's required in a properly structured SPIA are listed on the screen here. In order for an immediate annuity to meet the requirements of Medicaid, it must be completely irrevocable, meaning that we can't change any aspect of the contract after it has been purchased. Most immediate annuities are going to be irrevocable related to the payment stream, but they may not be irrevocable in the sense that we can't change the payee or the beneficiary. So if you're looking at an immediate annuity contract, you would want to make sure that it's not just the payment stream that's considered irrevocable, but the entire contract as far as the parties and every aspect of the contract is going to remain as is and cannot be changed. Also, the policy must be completely non-assignable, meaning that we would not be able to assign the income stream or the contract to a company like JG Wentworth or Peachtree, companies on the secondary annuity market that would purchase annuity contracts like this. So you're looking for non-assignable language as well. The actuarially sound language means that the annuity is going to return the full amount that is being put into the annuity contract. If that's, say, 100,000, that the full 100,000 is going to come back to the Medicaid applicant or to the community spouse within their Medicaid life expectancy. So we can do an annuity timeframe that is equal to their life expectancy or shorter, but we cannot do a timeframe that would be longer than the purchaser's life expectancy according to either the Social Security Administration table, or some states publish their own life expectancy table for purposes of determining the actuarially sound requirement. Another requirement of the annuity is that it must make equal payments without any balloon payment at the end. So prior to the Deficit Reduction Act, we could do balloon style annuities that would basically backload the amount of income that was going to be generated from the annuity and make a final balloon payment that was very large. And so we can no longer do a balloon payment. It must make equal payments. And then the final requirement of an immediate annuity would be that the contract must name the state Medicaid agency as a beneficiary. There is an asterisk here that is designating that there are some exceptions if there is a minor or disabled child, or some states allow for the Medicaid applicant to be named as a beneficiary before the state as well. So if you have any questions about any of these requirements, you can reach out to us and we can tell you how your state handles certain things as far as the annuity and the beneficiary designation. First, we're going to go through a case study that is dealing with a married couple, and we're going to consider a scenario where there is not any previous gifting that's involved. So in this planning scenario, we're going to consider a situation where we have one spouse that's in a nursing home and the other spouse that is remaining in the community or at home. And the goals when we're planning for this married couple is to obtain immediate Medicaid eligibility for the Medicaid applicant by converting their excess resources into an income stream, and then also provide the community spouse with peace of mind as well as sufficient income and resources so that they're able to maintain their lifestyle within the community. So we have a married couple situation where Roger and Nancy are married, and Roger is 80 years of age. He was recently diagnosed with dementia and has been in a nursing home since October 1st of 2024. He has monthly income of $2,000, monthly nursing home bill of $10,000 per month. And Nancy is his wife who is residing at home in the community. She is 75 years of age and has monthly income of $1,000 per month. The couple together own their home, a car, and around $400,000 of non-IRA bank accounts. So this is just money that is sitting in cash, the $400,000. And Roger and Nancy plan to apply for Medicaid to become eligible as of December 1st of this year. Roger, as the Medicaid applicant, is able to keep his personal property, prepaid funeral policy, and $2,000 of the $400,000 in cash assets. Nancy, as the well spouse that's at home, is able to keep the home, car, prepaid funeral policy, her personal property, and then $154,140 of the $400,000 in cash assets. When I deduct the $154,140 and the $2,000 that the couple is able to keep, I'm going to subtract that from the $400,000 in cash assets to determine that they have a spend down amount of $243,860 that they are over-resourced before they are able to apply for Medicaid and qualify for Medicaid for Roger. We are able to eliminate the excess spend down amount or the excess resources by purchasing a Medicaid compliant annuity with the $243,860, and we would purchase the annuity in the month of November so that Roger would be eligible for Medicaid as of December 1st. Nancy, the spouse that's residing at home, would be the annuity owner, the annuitant, and the payee. And with Nancy being 75 years of age, she has a remaining life expectancy of almost 12 and a half years. That would be 149 months would be the longest annuity term that we could purchase for Nancy based on her Medicaid life expectancy. But in this case, we decided to shorten the annuity term to a 5-year time frame or 60 months, and that would generate monthly income for Nancy at around $4,100 per month, so that the total payout is $246,000, which is slightly more than what was used to purchase the annuity, which is representing a small amount of interest that would be paid on the annuity contract by the insurance company. When we purchase the annuity for Nancy, we would be adding the annuity income of $4,100 to Nancy's Social Security income of $1,000 per month, so that we see that she has total income of $5,100. When we compare the $5,100 of income that Nancy has from the annuity and Social Security to the maximum monthly maintenance needs allowance, or the amount of income that Nancy is entitled to on a monthly basis, we're comparing the $3,854 as her MIMNA to her total income at $5,100. She does not have a shortfall from being able to meet her monthly maintenance needs allowance, meaning that she would not be receiving any of Roger's income through a MIMNA shift because she already has sufficient income to meet her needs according to Medicaid. And so when we're determining what Roger's copay to the nursing home is going to be, we would be simply taking his Social Security income of $2,000, subtracting out his $50 personal needs allowance that he's entitled to, and we determine that his copay to the facility is going to be $1,950 per month. The economic results of the 60-month annuity plan is that Roger and Nancy were anticipated to pay $10,000 per month for his care. We were able to reduce Roger's copay down to $1,950 per month so that they immediately experienced savings of over $8,000 per month. And Roger would be immediately eligible for Medicaid as of December 1st of 2024. The advantages of this type of plan is that we were able to obtain immediate Medicaid eligibility for Roger without any kind of penalty period or private pay period. We also were able to create sufficient income for Nancy through the Medicaid annuity. We created around $4,100 of additional income for her so that she's able to continue living in the community and maintain whatever expenses that she has associated to the home or whatever other needs that she would have remaining in the community. The annuity purchase is not going to cause a penalty period because all of the following language was included in the contract. Everything that we talked about that must be included as far as irrevocable, non-assignable, actuarially sound, equal payments, and the state being named as a beneficiary. So this transaction would be considered a compensated transfer that is not going to cause any kind of penalty period or gift for Medicaid qualification purposes. The potential disadvantage is that the state Medicaid agency is going to be the primary beneficiary on Nancy's annuity. If she were to predecease the term of the 60-month annuity contract, the state Medicaid agency would have a right to recover against the annuity to the extent that they provided Medicaid on behalf of Roger. This would be at the Medicaid reimbursement rate that they are recovering against the annuity, and anything that would be remaining in the contract after the state is paid would go to the contingent or secondary beneficiaries if Nancy did predecease the 60-month term. In order to reduce the likelihood that Nancy will predecease the term, we can shorten that to something less than 60 months, but we would want the annuity income to remain reasonable based on the amount of income that is going to be generated from the annuity contract and not create huge monthly annuity payments from the annuity contract that may potentially raise red flags with the Medicaid office. If we now consider a fact change where we have previous gifting involved, we can consider a situation where when we're planning for Roger and Nancy and you're reviewing the client's financial statements, you discover that Roger and Nancy have made transfers which could be possibly gifts according to Medicaid of around $20,000 over the last 5 years. We would first have to determine if the transfers will be treated as gifts or a penalized transfer. So we would be looking to see, are the transfers of $20,000 considered a gift or a compensated transfer? So a gift according to Medicaid is going to be a transfer of assets for less than fair market value, or an uncompensated transfer that is done during the look back period that is going to result in a penalty period or a private pay period. A compensated transfer, on the other hand, is going to be a transfer of assets by a Medicaid applicant for which the applicant received fair market value, and a compensated transfer is not going to result in a penalty period. So an example of this would be that the parent or the Medicaid applicants made a transfer to a son or daughter in exchange for a vehicle. So they're purchasing a car that we can prove that fair market value was paid for the vehicle, paid to the son or daughter in exchange for the cash that was transferred from the parent over to the son or daughter. The look back period is the period of time that Medicaid can examine an applicant's finances to determine whether an uncompensated transfer has been made. In all states currently, other than California, have adopted the Deficit Reduction Act of 2005, which includes a 60-month look back period for any gifts or uncompensated transfers. So only gifts that have been made within the look back period are counted and reported to Medicaid. With all states having a 60-month look back period other than California, California's look back period is currently a 30-month time frame. Some states will ask for 5 years worth of bank statements or financial statements when applying for Medicaid, while as other states will just ask if there have been any transfers or gifts that have been made within the 5-year look back period. So that's kind of a state specific thing as to whether you're actually going to have to supply 5 years worth of bank statements, or if you would just have to disclose any gifts that have been made within that look back period. The penalty period associated to any gifts or uncompensated transfer is not going to start until your client is considered to be otherwise eligible for Medicaid. The otherwise eligible criteria is proven by the person or the married couple actually being in a nursing home and applying for Medicaid. So they must meet a nursing home level of care and be applying for Medicaid in order to start that penalty period. We also must have the applicant and their spouse's assets that are reduced to the asset limitation for eligibility purposes. So we must prove that the person is asset eligible for Medicaid or spent down to the $154,000 that we talked about for a community spouse in order to start the private pay period or the penalty period as well. The applicant must apply for Medicaid, and we must prove that the applicant is actually income and asset eligible for Medicaid, except for the fact that they have made this transfer or a gift. Not all transfers will be penalized. So if we're able to prove to Medicaid that the transfer has been made for purposes other than qualifying for Medicaid, some of the examples that would fall under this category would be a consistent pattern of giving to a place of worship. So if you have a couple that has consistently been giving to the church for the last 10 or 15 years, those would not be transfers that Medicaid is going to consider to be penalized, because we can prove that the person was doing this long before they actually needed to apply for Medicaid, and it's a pattern of giving that they were doing before the person got sick. Also, gifts that were made well in advance of the person needing care is another scenario where you're usually able to prove that gifts were made for purposes other than applying for Medicaid. And then finally, small or nominal gift amounts normally would not be considered accountable penalized transfer. Some states will actually publish in their Medicaid manuals that anything that is less than, say, $1,200 or $1,500 is not going to be considered a penalized transaction. If your state does do that, that makes it a little bit easier, because then you're not looking at all transfers that have been made or small gifts that have been made within the last 5 years. But if there are small amounts that your state does publish a certain amount, then that makes this a little bit easier as well. The exception to prove that the person made transfers for purposes other than qualifying for Medicaid can in some cases be difficult to prove, so it may not be just a slam dunk of being able to say, yes, this person made this transfer and it wasn't to qualify for Medicaid, especially if the transfer was done soon, relatively soon prior to applying for Medicaid. Then it can be harder to prove that the transfer should not be a penalized transaction. If the $20,000 transfers are not penalized and the Medicaid compliant annuity is purchased, then Roger would be eligible for Medicaid as of December 1st of 2024. But if we were unsuccessful in proving that the $20,000 gifts were made for purposes other than qualifying for Medicaid, then we would have to calculate what the penalty period associated to the $20,000 in gifts would be. So we're usually going to look at calculating the potential penalty period by taking the number of months that a Medicaid applicant is going to be ineligible for Medicaid because of an uncompensated transfer or gift that was made during the look-back period. The formula for calculating the penalty period is going to be taking the total gift amount and dividing that by the divestment penalty divisor that is published by your state Medicaid office. And this is going to tell us what the penalty period or the private pay period is. The divestment penalty divisor is a number that is published by the state Medicaid department that's supposed to be the average cost of 1 month in a nursing home in your state. So this is going to vary by state, especially depending on the region of the country that you're in. So Pennsylvania's current divisor is around 11,500, whereas Arkansas, it has a divisor currently of around 8,500. So this varies by state. If you have questions about what your state number is, you can find that on our website at ashford.com. Otherwise, your state Medicaid manual website will usually have that information as well in order to tell you how to calculate a penalty period. If in this case, we assume that Roger resides in a Pennsylvania nursing home and he is trying to apply for Medicaid as of December 1st, he's made a gift of $20,000 that Medicaid is going to penalize. We assume that we're using the Pennsylvania divisor that we just talked about of around 11,500. We would be taking the gift of 20,000, dividing that by the divisor of 11,500, and calculating that the penalty period or the private pay period is 1.73 months that Roger would have to privately pay for his care before Medicaid would start paying based on the previous gifts in the 5-year look-back period. Some of the solutions that we would suggest in order to deal with previous gifts would, number one, be to accept the penalty period. If there's not another solution that we can offer, or if the money can't be returned, then we would be accepting whatever the penalty period is associated to the previous gift. We can also have the family return the gift in order to cure it or to undo a transfer that would result from the gift. And then finally, the family can consider a promissory note if that's something that your state Medicaid office allows as a potential planning technique. So the first option would be to accept what the penalty period is. And so if we don't deal with or cure the previous gifts of $20,000, and instead of Medicaid starting December 1st, Roger is going to be responsible to privately pay for his December nursing home bill and part of January, because we calculated the penalty period to be 1.73 months. Medicaid would start paying for Rogers Care as of January 22nd of 2025. The funds that we would use to privately pay for December and January would either come from the annuity payments that we set up for Nancy, the 4,100 plus their other income, or it can come from the community spouse resource allowance of 154,140 that Nancy would be able to keep as her resource allowance. Under the first option, accepting the penalty period, the annuity plan would remain the same because we would have to establish that the couple is asset and income eligible for Medicaid when the application is submitted. And so instead of achieving December 1st eligibility, Medicaid eligibility would be delayed to January 22nd of 2025. And the private pay costs for December and January are likely either going to come from the annuity payments or from the resource allowance of 154,140. If you recall, Roger's nursing home cost was around $10,000 a month. He had monthly income of $2,000. So the shortfall on a monthly basis was $8,000 that he was going to come out of pocket. If we consider the private pay amount coming out of the community spouse resource allowance of 154,140, and we subtract out around 1.73 months of private pay costs, that's going to cost them around $13,840. So the amount that Nancy is going to have left as her community spouse resource allowance is $140,300 after privately paying for the 1.73 months. The advantages of this first option is that it's a pretty simple strategy. We're still going to just use one planning tool, the Medicaid compliant annuity, to establish that the couple is asset eligible and then start the 1.73 month penalty period. Pretty much all states recognize the annuity strategy as a plan, and Roger is going to become eligible for Medicaid shortly after this plan is put into place in January. The potential disadvantages of this plan is that we aren't obviously able to achieve immediate Medicaid eligibility in December. It's going to be delayed by the 1.73 month private pay period. And so the private pay costs are going to have to come from either the annuity payments that are paid to Nancy or from the CESRA amount that Nancy is going to keep. In our example, the resulting penalty period was relatively short. It was 1.73 months. So using the annuity payments and the CESRA amount to privately pay for under 2 months likely is not going to be that big of a financial impact on the client. But if we were dealing with a situation where the previous gifts were more substantial, let's just say 200,000 in previous gifts, this is going to result in a lot longer penalty period. And so the family could consider purchasing two annuities in that case, one annuity that would be owned by Roger to cover the private pay period of 17.32 months as a result of making a $200,000 gift. And then the second annuity would be owned by Nancy, and that would be purchased with the overage amount that needs to be spent down in order for the couple to be asset eligible. The two annuity purchases could look something like this, where Roger owns one annuity. He would purchase that annuity for around $135,000. The term would be a 17-month time frame to match what the private pay period is. It's going to pay him just under the shortfall that he has each month. He had an $8,000 a month shortfall, so we would set up the annuity to pay slightly less than that at $79.50. And then with the couple still having to spend down amount of $243,000, we would have to purchase a second annuity for Nancy to get the couple spent down. And so her annuity purchase would be around $109,000 that she would purchase an annuity for. And we just kept the annuity term at 60 months because that's what we illustrated for her the first time. The second option that we would have would be to return the gift and basically cure the resulting penalty period. In order to avoid the 1.73 month private pay period, the $20,000 could be returned to Nancy. And if the gift is fully returned or cured, a private pay period is no longer going to exist. And so the annuity purchase, if the previous gift is returned, would be increased by $20,000 to accommodate the annuity amount would be increased by $20,000 to accommodate the previous gift being returned. So the original annuity that we talked about was going to be purchased for $243,000 approximately, but if we increase that amount by the gifts that are being returned and also take into consideration that the couple is still capped at $156,140 as their protected resource amount, we know that the annuity needs to increase to $263,860 in order for the couple to be asset eligible. This illustration here is just showing that the annuity amount is increased. We're still going to structure the term over a 60-month time frame. So the annuity monthly payment is going to increase from $4,100 a month to $4,420 per month, and also the total payout is going to be slightly greater than what was put into the annuity, representing the interest that's paid. By returning the $20,000 and increasing the annuity amount, Roger is going to be immediately eligible for Medicaid as of December 1st. If the full $20,000 gift amount cannot be returned to Roger and Nancy prior to the annuity purchase, and a portion of the gift is going to be returned after the Medicaid application is made, it's important to find out if your state recognizes partial cures in order to reduce the penalty period. If you are not sure about partial cures and if your state recognizes them, feel free to reach out to us and ask. Basically, some states say that in order to cure a gift, the full gift amount needs to be returned in order to cure the gift, whereas others will allow for a partial return of the gift in order to cure what the partial amount is associated to a penalty period. The advantages of option number 2 would be that it's, again, a pretty simple strategy where we're only using one planning tool, the Medicaid compliant annuity. Also, like I said, most states do recognize the annuity for married couples when we're doing planning. Roger would be immediately eligible for Medicaid because the gift is returned. And the disadvantages would be that this may not be an option if the previous gifts cannot be returned, depending on who the gifts were made to and when the gifts were made. If the gifts cannot be returned, then the penalty period is going to remain intact and they'll have to privately pay for their care if we don't have any way to get the money back to Roger and Nancy. The final option is option number 3, and this involves using a promissory note. If we want to assume that Roger and Nancy are trying to avoid the 1.73 month penalty period and immediately qualify for Medicaid as of December 1st, The $20,000 in gifts could be recharacterized as a loan or a promissory note, assuming your state allows for the use of a promissory note when doing Medicaid planning. With a promissory note, the contract must contain all of the language that you're seeing on the screen in order for it to be considered Medicaid compliant. It's pretty much all of the same language that must be within an annuity contract. It must be actuarially sound, make equal payments, no deferral or balloon payments. It prohibits cancellation on death, and then in order for the note to be non-countable, it must be irrevocable and non-assignable, which is similar to a Medicaid compliant annuity as well. The loan could be structured over Nancy's life expectancy of 149 months that we calculated based on her age of 75, or a shorter period of time, and it could make monthly payments back to Nancy for as little as $140 a month, with the payments going directly to Nancy, the community spouse, so that it's considered to be her income. As a result of putting the annuity and the promissory note in place, Roger would be immediately eligible for Medicaid starting December 1st. The annuity purchase is going to look exactly the same as the purchase that we talked about when there was not any gifting. Roger's monthly income is going to remain at $2,000 from Social Security. And when we consider the promissory note payment, Nancy's monthly income is going to increase from $5,100 per month up to $5,240 per month. This does exceed the monthly maintenance needs allowance. So again, she's not going to receive any of Roger's monthly income under the income shift, but his copay to the nursing home is going to remain at $1,950 per month as a result of putting the annuity and the promissory note in place. When we look at the income calculations for Nancy, we would be considering her Social Security income at $1,000 per month, plus the annuity income at $4,100 and the promissory note at $140 per month. That's where we're getting the total of $5,240, and we see that that $5,240 exceeds the monthly maintenance needs allowance that Nancy has at $3,854, so that Roger's copay to the nursing home is going to be his $2,000 from Social Security less the $50 personal needs allowance. One note of caution, there are several states that do not recognize promissory notes as a planning tool. So this is something that you would want to consider before just putting a promissory note in place to pay money back to the community spouse if your state does not recognize that as an allowable planning tool that would be recognized by your state. The advantages of the annuity and promissory note plan together is that we achieved immediate Medicaid eligibility for Roger. Most states, like we talked about, recognize the annuity planning for married couples without any issue. Also, the promissory note can be structured with payments that are affordable for the giftee to pay back. So if it may be a situation where a gift of, say, $20,000 was made many years ago, but the child isn't in a position to return the full $20,000. If they're able to return $140 a month and recharacterize that as a note, then that would be a way to avoid the private pay period if that's something that your state does recognize. The possible disadvantages is that not all states recognize the promissory note as a planning tool like we talked about, and then this is just going to be a little bit more complex planning when we're talking about doing both an annuity and the promissory note in order to cure the previous gift that has been made or recharacterize the previous gift. Some of the factors to consider when you're deciding which option to choose or when the client is looking at what options are available to them. Obviously, the amount of the previous gifts, whether it's a $200,000 previous gift or $20,000, is going to impact which option makes the most sense. How long is the penalty period going to be? Is it going to be a 17-month time frame or 1.73 months? That's a big difference as far as the amount that would be necessary in order to privately pay when you're talking about the amount of resources that must be available to the client in order to cover that private pay period. Another consideration is whether the previous gifts are curable or can be returned to the Medicaid applicant or to the spouse in order to avoid that private pay period. Another consideration is whether your state does recognize each strategy as a planning technique. So does your state recognize partial cures or the promissory note as a planning opportunity? And then also, we would be considering the health of both spouses. If we have a situation where the private pay period associated to previous gifts is extremely long and we only anticipate the Medicaid applicant living for a couple of months, then it may make sense to simply privately pay and just avoid applying for Medicaid in a situation like that. So we would want to consider how long we anticipate the private pay period to be and how long we anticipate the Medicaid applicant to survive as well. And then finally, the amount of resources that the couples own in order to cover a private pay period. If there are some situations where we have a couple that doesn't have enough money in order to cover the previous gifts that have been made, the private pay period associated to the previous gifts. And so really a scenario like that, we would have to get the gifts back in order to develop a plan that would make sense if there aren't enough remaining resources to cover that private pay period. I'm able to take questions now in the last 5 minutes or so. I'm logging in here to see quickly if there are any questions from people. I'm not seeing any at this time, but if anybody thinks of any questions after today's presentation, feel free to either email me at amber@ashford.com or give us a call at the phone number that you're seeing on the screen. We do have a question here. It is asking, can you explain how you're able to shorten the payout term on the annuity without causing an actuarially sound problem? So there are currently 2 states, Oregon and Washington, that have actuarially sound requirements that require that the annuity must pay out for a specific period of time. So Oregon's rule is that the annuity time frame must be within 12 months of the person's Medicaid life expectancy. And then Washington has a rule related to the annuity not being shorter than a 5-year time frame if the person's life expectancy is greater than a 5-year time frame. But every other state other than those 2 will allow for the annuity to be shortened to something less than what the actual life expectancy of the annuity purchaser is, because we would be able to prove that we are returning the original investment amount that is used to purchase the annuity within the person's Medicaid life expectancy. It does not need to be equal to the person's Medicaid life expectancy. It just has to be within their Medicaid life expectancy if you are not in Oregon or Washington and you are able to purchase an annuity that has a shorter time frame than what is actually required by the state Medicaid agency as far as a life expectancy. We have another question here. Is there any reason mom can't receive note payments and later gift them back to the payor? So there is not any issue with the community spouse being the one that is receiving the note payments. The making a gift later would really come down to a state specific question, because there are some states that after you get one of the spouses on Medicaid will look at gifts that have been made by the community spouse after the Medicaid application has been approved for the Medicaid applicant, and then other states don't look at any gifts that have been made by the community spouse after the Medicaid application has been submitted and approved for the Medicaid applicant. So that would be a state specific question that we could look into if we know which state you're trying to plan in. Those are all of the questions that we have from today's presentation. Like I said, if there's anything that comes up afterwards, feel free to shoot us an email or give us a call. And then be on the lookout for the December webinar. We're going to be talking about how to deal with annuities that don't comply with Medicaid and the different types of annuity contracts that are out there, what kind of planning we can do with different types of annuities. If anybody has any questions, feel free to reach out. Otherwise, I appreciate everybody's time today. Thank you and take care.